you. As I said last time, they gave me the boring parts, but it's stuff that we need to get through and you need to have some understanding of. So before I start, last time when I was with you, we talked about contracts. And there are three parts to a contract. Can you tell me what the three parts for a contract are? I will give you a clue. The first part is an offer. So remember, I think you offered to build my house for me. So the first part of a contract is the offer. The second part is acceptance. So I accept your offer. And the third part is the consideration. How much money? Okay, so those are the three major parts of a contract. An offer, an acceptance, for a consideration. Okay. So we also looked last time in contracts and what the implied terms of a contract are under the Building Act. So I said to you, if you have a residential project over $30,000, you must have a contract. Okay, it is a legal requirement for any project over $30,000 to have a written contract. And the minimum requirements of a contract are set out in the Building Act. And I gave you a list of what those were. So even if you got into a situation where you had no contract, where you weren't complying with the Building Act, you had no contract, you'd done the work, that still applies. Remember, I said you cannot contract out or you cannot escape the legislation. They always apply. Okay, so today we're going to look a little bit more at oops, I put the wrong one. Hang on, found it. We're going to look at a little bit more about building law. We'll look at the New Zealand legal context, the Building Act and regulations, code compliance, insurance requirements, and if we've got time, employment law and employment agreements. There's a lot of stuff here. You've got the notes in front of you. 50 odd slides. So this is like death by PowerPoint, but we'll see if we can get through it. And I promised I'll have a break. So when you get too tired listening to my English. Whoops. So, the New Zealand legal context. So, the rule of law, or law, are the rules that bind people living in a community. So, if we are living in a society or in a community, it's accepted that there are laws that bind us or rules that bind us all together. Can't get the right button. So laws protect our safety and our well-being. Laws ensure our rights as citizens in New Zealand against abuses by other people, by organisations and in fact by the government itself. So we are protected by law against abuse of government. And remember, statutes are what is created by Parliament. So they are legislated through the lawmaking process, and they are voted for in the New Zealand House of Representatives, known as Parliament. So that is statutory law. The other sites, and we've been making statutory laws for 165 years. So New Zealand is still a very, very young country. So that is the length of government that has been in New Zealand, 165 years, a very, very short period of time. But nevertheless, we have experience of making law. And in addition to statute law, we have what's known as common law. And in New Zealand, it's English common law. Because our historical background is British English, that common law now applies to us. And that is common law that has reached back for many, many centuries. So it's a long established legal process of which New Zealand is part. So it is based on precedent, past decisions of judges. That's the common law. So it is not passed by statute in the Parliament, it is established by the court process itself. So we have two types of law, statutory law and common law. So New Zealand, as I said, New Zealand's system is modelled after the British and the fact that we've got English common law, but our model of government is also modelled on the British. And it is based on what we call a separation of power. So there are distinct parts of government which are separated legally. And so the first one is the legislature. Okay, this is Parliament. These are the people that sit in Wellington. These are the people that we vote for. Okay, they are the people who vote and pass the law. The second branch of government is what's called the executive. The executive consists of ministers. So this is, at the moment, this is the coalition government. This is the Labour government. They appoint ministers and they form the executive, okay, along with government departments. So this branch decide policy and administer the law. At the moment, this branch is talking about capital gains tax, for example, as a matter of policy. Okay, when that policy is formulated or decided, it will then go to Parliament to be voted on. The third part of our government is the judiciary, is the law, the legal structures. So the judiciary consists of all judges, and their role is to interpret and apply the law. So we have three distinct branches of government. And it is important for us that this judiciary is completely independent of the government. So they cannot be influenced by the government. So this is the system that we have in New Zealand based on the British Westminster system. Three branches of government separated. So we've talked about this already. There are two main sources of law, statutory law and common law. And I note here that English common law applies in over 30 countries. And those countries are generally the ones that have had the British influence. So this is historical. So this includes the US, for example. So the US adopts English common law. Well, they call it Anglo-American law, but it is actually English common law. So, and interestingly, also Hong Kong still maintains English common law as a civil law. So there are two streams of law. Civil law, that's disputes between individuals or companies. That's a dispute between you and I. Okay, and it's often about money. But it could be about property, or it could be about the cause of harm. So if I caused you harm in some way, okay, you can commence a civil proceeding through the court. So I haven't committed a criminal act, but I have caused you harm. That is now covered by civil law. The other branch of law is criminal law. So this is criminal law, generally prosecutions brought by the police, but not necessarily. In terms of building and construction, okay, you can commit a criminal offence, and the Ministry of Business, Innovation and Employment will take proceedings against you under criminal law. If convicted, a person is sentenced in accordance to the law and to the statute, and they have a right of appeal. So that's a broad context of our legal system and where the Construction Act sits. And then we look at the court system. There are a number of levels of court in New Zealand, and most of the work is done in this district court here, but there is a High Court, and above that the Court of Appeal, and the highest court in New Zealand is the Supreme Court. So we have down here disputes authorities, so this sits below the district court, and so these are for small disputes. If you have a small dispute with your neighbour, you may take them to the disputes tribunal, and the limit currently is $15,000. So if the dispute is less than $15,000, okay, for example, I'm driving down the road and I smash into your car, I've got no insurance, so the insurance won't pay. You take me to the small claims tribunal to get the money back for the damaged car. And by agreement, that $15,000 can go up to $20,000. So if you've got a case that's maybe $16,500, that can still be heard in the small claims tribunal if you both agree. If it's over $15,000 or over $20,000, it would go into the district court as a civil claim. So these are tribunals here, lower level, that apply to the construction industry: disputes tribunal, weathertight homes tribunal, and tenancy tribunal. And in fact, the weathertight homes tribunal has authority up to $350,000, so it's a little more than the disputes tribunal. So in terms of the district court, this is where most of the criminal cases are heard, in the district court, and civil cases up to $350,000. So if you have a civil case at $300,000, that will go into the district court. If it's $400,000, that will go straight to the High Court. So in the High Court, this is where most serious criminal cases are heard. So things like murder, but also complex civil cases will be heard in the High Court. So for example, the collapse of Mainzeal construction and the prosecution of the directors that has occurred in the High Court. Okay, so complex civil cases or anything over 350,000. The Court of Appeal is generally the last court of appeal in most cases. So a decision made here can be appealed in the district court. A district court decision can be appealed to the High Court. And a High Court decision can be appealed to the Court of Appeal. And up here, the Court of Appeal, their decision supersedes everything else that's gone before. So all of these decisions are superseded or overtaken by a decision of the Court of Appeal. So previously, after the Court of Appeal, under the old system, we used to then take that appeal to the Privy Council. So the Privy Council is a court that sits in the UK. Okay, and it consists of Lord judges. But for the last 10 years, we have now established our own Supreme Court, which has got rid of, for New Zealand, the Privy Council. And so cases may go to the Supreme Court if the court grants leave to appeal. In general, the case needs to raise a significant legal point or a matter of general public importance. So, I reading in the paper yesterday the guy Lundy, who was convicted of murdering his wife and small daughter back in 1998, has gone through all of this process, okay, and is now applying to the Supreme Court for his case to be heard again. So it is very unusual to get a case to the Supreme Court. So this is the structure of statutory law. So the statutory law is the Act of Parliament. So we talk about an Act of Parliament, that's statute law. So that says what the law is. But underneath that are regulations. How are we going to implement this law? That's set out in the regulations, and then underneath that there are a whole lot of codes and standards which are performance requirements. So this is very, very typical of the Building Act. So this part here is legislation. So this goes through Parliament. The codes and standards are established by other statutory bodies, not by Parliament. So, in terms of the Building Act 2004 sits at the top. And I've said here, plus amendments. So almost every year there are amendments that are made to these acts. They get changed. So while the substantive act, while the main act still stays in place, 2004, it has had multiple amendments through the years. The building regulations are ones that still apply, 1992. But they have largely been superseded, but they still sit in place. And the codes and standards is what you have to work to, which is the building code. So this is how the structure works. We have the Act at the top, the regulations, and then the codes that sit underneath it. In our case, the building code. So that's statute law. We'll just quickly look at common law. And we get down to legal terms now. And so common law, tort, tort, this is a strange term, but that is, tort is common law where you have done something wrong to another person. So a civil wrong. It causes the claimant, that might be me, to suffer loss or harm, resulting in legal liability to the person who commits the tortious act. So this is common law and the law of tort, where you are caused harm. The tort can cover intentional negligence, financial loss, invasion of privacy, and many other things. So if you are negligent in your actions, you may find that you have civil proceedings taken against you under the common law of tort. In tort law, the purpose of any action or lawsuit is to obtain a private civil remedy, such as damages or financial compensation. If I'm going to claim that I have suffered loss, you have to be able to establish that it was caused by you. Okay? So, common law. So, that's a legal context. So that's a background of where the Building Act sits. Okay, so it sits as statute law, supported by regulations and supported by codes. If we now look at the Act in more detail, I asked the question, you've got my notes in front of you, why do we have a building code? Why do we have a Building Act and why do we have a building code? And we'll just give you some context as to why these things are in place. 1931 was a very, very significant year in New Zealand, because that was the year of the Napier earthquake. It was Napier and the Hastings in the Hawke's Bay. A large earthquake which destroyed both towns. Nearly all the buildings were destroyed. 256 people killed. This is when the population of New Zealand was, I don't know, 1 million people. So a very high number of people compared with the population. So this was a very, very major event. And you have a look at the buildings. They're completely flattened. They had no earthquake strength at all, because there was no building code, essentially. If we go forward a little later, 1947, okay, it's probably one of New Zealand's most serious fires in a department store in Christchurch. Once again, the building completely destroyed. 41 people killed in the fire. Firemen thought it was just a cellar fire. They didn't realise that there were people trapped inside. So, a very, very significant part of our New Zealand building code now is about protecting life and protecting people in case of a fire. Okay, so it is about the protection of life, not necessarily the protection of the building, but the protection of life. Going forward a little bit further, now this is in my memory, okay, 1968. Buildings completely destroyed and flattened by wind. Okay. The so-called Wahine storm in Wellington. The Wahine was a ship, a ferry, that went between Wellington and Christchurch. okay, it sunk. It sunk in Wellington Harbour. It hit the reef coming into Wellington Harbour, and then the wind blew it into the harbour, and it sunk with, doesn't say there, 57 people drowned. But the Wahine storm is generally recognised as one of the most significant storms that have hit New Zealand. Okay, the buildings blew apart. Okay, the buildings weren't connected. The roofs weren't connected to the top plates. The top plates weren't connected to the studs. The studs weren't connected to the bottom plates. The bottom plates weren't connected to the floor, and the floor wasn't connected to the foundation. It all blew away. Then, even more recently, 2005, another issue, weather tightness. And this sets the immediate context for a lot of our building code and our building act, weather tightness issues. So relatively new buildings were not weather tight and they started to rot. You know, in New Zealand, how do we build houses? With timber framing. Okay, one of the few countries that uses timber framing to quite the same extent. There are only a few countries like North America, US, Canada, they use timber framing. Okay, very hard to see a timber frame house in China. Okay. One of the issues, or there were several issues, but a significant issue was the use of untreated timber. The research said that if you kept the timber dry, it was okay. It didn't rot. Well, that seems logical, doesn't it? If you keep the timber dry, it won't rot. So the use of untreated timber was adopted. And it was possibly for very good reason, like environmental reasons. The use of treated timber and the use of treatment was the use of chemicals, environmental impacts. People were handling treated timber, there were health issues. So there were some advantages to not use treated timber. But of course, the buildings weren't waterproof and they leaked. And where the leaks occurred, the timber frames rotted away. So a good part of the building code is now about weather tightness. And if you're interested, there is a Brands seminar coming up on junctions, a 3-hour seminar on how you use flashings. I don't know which day it is, it's going right through the whole country. Maybe it's on a Friday afternoon, so you can't go in Auckland. I'm not sure. But there is a weather tightness seminar coming up, sponsored by Brands. And it's looking at junctions and joints in buildings, because that's where the water generally gets in. So we had all of these events, and we talked about 1931 and the earthquake in Napier, but along came 2011 in Christchurch. Building collapse. Now 2011 was the most catastrophic earthquake in Christchurch. It had been preceded by an earthquake in 2009. The 2009 earthquake, there was no loss of life and only a small amount of damage. And I had been travelling in 2009 in Chengdu in Sichuan, and they were commenting to me, oh, you've had an earthquake in Christchurch. There was no one lost their life, because in our earthquake in 2008, how many people were killed? 300,000. And they were saying, oh, it's because of your building code. Your building code and your building practice is better than we do in China. And I said, maybe. 2011, another earthquake came. The building collapsed. 185 people killed, mostly in that one building. Now that one building is still subject to legal process, okay, where the Institute of Engineers, Engineering New Zealand, has been instructed to continue to take proceedings against the design engineer. They've been instructed by the Court of Appeal, I think it is, to commence proceedings. So this building collapsed because of inadequate design. And you can see it's a very, very classic example of a structural failure. The floors just pancaked, as they say. They just fell on top of each other. So the connections of the floors to the columns and the shear core weren't strong enough, and they just collapsed on top of each other. And 120 odd people were killed, were trapped in that building. Okay. The significance of the 2011 earthquake has meant that we have changed our design codes. That 2011 earthquake had significant vertical acceleration. Vertical acceleration. The previous earthquakes, and our understanding of earthquakes, was about horizontal acceleration. The ground shakes like this. Okay? In that 2011 earthquake, the ground went up and down. Okay, so completely different set of forces on the buildings. So the Christchurch earthquake has meant significant strengthening of buildings has occurred or is occurring in New Zealand. So all buildings now have to meet a percentage of the current earthquake code. So if you've got an old building out there in Onehunga, you may have to strengthen that to 35% of the new code. And if you can't strengthen it to 35%, you demolish it. Okay, so there's a timeline on that. So these are major events that have shaped our thinking in terms of building code. So the purpose of the Building Act is to provide regulation of building work, the establishment of a licensing regime, and the setting of performance standards. One of the issues with leaky buildings was that there were many, many unqualified people putting buildings together. So with little understanding about what they were doing. So that has meant that we've now introduced a licensed building practitioner scheme. So maybe it's your aspiration to become a licensed building practitioner. Anyone here is a licensed building practitioner? Okay. Well done, congratulations. All work must meet certain standards. Standards are set out in the Building Act legislation and regs and determine how the work can be done, who can do it, and ensure that there's a system of checks and consumer protection. So if I'm buying a house from you, I have some protection. That's the purpose of the Building Act. So once again, just quickly run through some of the historical context of the Building Act. Where has this come from? I've said 165 years we've been making legislation, but it wasn't until 1876 that councils adopted power to control buildings. 1935 is an important year. Remember, 1931 earthquake, 1935, the first standard model bylaw introduced into New Zealand. 1936, first issue of a state housing specification. So the Labour government was elected for the first time, 1935, and they set about building lots of houses, just exactly what we're doing now in New Zealand, trying to do. Okay, and they developed their own specification of how these houses were to be built. And if you look at many of the houses, state houses, if you drive through Mount Roskill, for example, you'll see these houses there, built in the late 30s, early 40s, state houses. They are still there, still serving their function, okay, but they were built to a standard specification. (1964), another new model bylaw was introduced, NZS 1900, and in particular Chapter 6.1, construction requirements for buildings not requiring specific design. That was the predecessor of NZS 3604, which you're all familiar with to some extent, 3604, which is the current timber framing code. Okay, NZS 1900, Chapter 6.1 was the predecessor. How, just out of interest, NZS 3604 2011, how many pages? Okay, I don't know how many pages. It goes to 300 pages, that standard. NZS 1900 was 30 pages long. 30 A5 pages, small pages. You could just about do anything you liked. And once again, this is in my lifetime. I've used this code to design and build buildings. And this was a time in Auckland where there were 40 local authorities, 40 local authorities, 40 councils. All right, and I could be building a building on that side of the street, and I'm in only Hunga Borough Council, and I come onto this side of the street and I'm in Mount Wellington Borough Council. And they're all interpreting NZS 1900 differently. I've in the past had many arguments with building inspectors. And I had one inspector say to me, "Oh, that's just the way we do it in Henderson." But I said, "You're the only place in Auckland that does this." "Oh yeah, that's okay. That's the way we do it in Henderson." And so literally, from one side of the street, you could have different requirements. It was a terrible situation to work in. So, 1978, NZS 3604 was introduced. So this was a common standard that was to be adopted by all councils. It was a major revision in 1999 and again in 2011. It got thicker and thicker. 1991, the Building Act, first Building Act was introduced. 92, the regulations to support the Act implementation. And once again, just to show how this works, the pyramid of legislation, the Building Act, the Building Code and the standards. 2004 now is the Building Act, which is the primary legislation governing the building industry. 1992 regulations still are in place, but they've been heavily amended. And the building code is contained in Schedule 1 of the building regulations, sets the minimum performance standards. And that's something that you'll be becoming very, very familiar with, the building code. So the Building Act aims to improve control and encourage better practice. This means the provision for the regulation of work to ensure that people can use buildings safely. Remember I said, one of the issues is getting people out of buildings, but it's also about using buildings safely. So it's about protecting people so that they can escape in a case of fire. To ensure buildings contribute to the health and physical well-being of people, independence of people. So we have a whole lot of disability provisions that we now have to include, particularly in public buildings. And we also have issues to promote sustainable development. So those are the aims of the Building Act. To ensure people can use the building safely, to ensure people can escape in the case of fire, to contribute to the health, physical independence and well-being of people, and to promote sustainability. Those are the aims of the Building Act. In terms of application, the Building Act applies to all building work, alteration, demolition or removal. There are some exceptions. The Building Act, for example, doesn't apply to give me an example, small garden shed. 20 square metres, yes, 20 square metres. That much, very small. Okay, a structure less than 1.5 metres high. Okay, or a pergola or a sunscreen structure don't require a building consent. Some maintenance work doesn't require a building consent. So if you're doing repair work on a house, as long as it's limited, you're replacing some of the exterior cladding. You're not replacing all of the cladding. Or the maintenance is repairing an element that has lasted over 15 years. You don't need a building consent. But generally all building work, alteration, demolition and removal requires a consent. Also, a consent for the maintenance of systems within buildings, such as lifts and fire protection. Okay, so these are in commercial buildings. Where you're going to do alterations to these things, they need building consent. The Act doesn't cover planning and resource management. Doesn't cover planning and resource management, that's covered under other legislation. And it doesn't cover occupational health and safety. That's covered also by other legislation. So the Building Act applies to building construction, alteration, demolition or removal of buildings. Your responsibility. Owners, designers, builders. You are, I presume, will take the role anyway of being a builder. Builders and building consent authorities are accountable for their role in obtaining consents and approvals, ensuring plans and specifications for building work meets the building code, ensuring